The next speaker is Ms. Lee de Souza, who did speak earlier. She's going to speak on the same topic, RAF4, Appeal Tribunals, Constitutional Principles, Right of Fair Administrative Action, Access to Courts, and the Need for Training. Lee? You'll see you spoke too softly.
I'm normally told I'm too loud, but I'll try. Okay. So I've been asked to speak about the RAF4 process. I think what's important to note, if one conducts an analysis of the process, is the striking and, I dare say, dangerous parallels that can be drawn if one looks at this process and compares it to the administrator that's created under RABS. There are striking similarities. And I think the most striking similarity is the lack of access that the victim has to our court system. I'm going to look at Regulation 3 in a bit more detail, and just to explain the difficulties that we experience on a practical level. Remember, Regulation 3 is the regulation which deals with the entitlement of an individual to non-pecuniary loss or general damages. You're only entitled to general damages currently if you sustain a serious injury. The process is two-pronged. You can either suffer 30% whole person impairment, or you can be declared serious, or your injuries can be declared serious under the narrative test. As far as I'm concerned, I think that the application of the AMA guide should be taken away completely. Largely, our injuries are being declared serious or non-serious on the basis of the narrative test anyway. But if one looks at the process, you start by the RAF, who needs to make a rejection, or election, I should say. Most of the time it is a rejection, but make an election in terms of Regulation 3 to either reject the RAF4 serious injury assessment or to refer to their own experts for assessment. The biggest problem with this section is the delay that's taking place. A lot of the time, these rejections are being made on the steps of court. And you're taking 2.5, 3 years often to get to court, and you're then only commencing your dispute resolution process once you've got to the steps of court. It is a problem. So what happened is there was a matter that came before the court, the Duma decision, and unfortunately the courts held that it is the obligation of the accident victim to chase the RAF every step of the way. So we have, and I say we because I do perform predominantly plaintiff work. So we have the Promotion of Administrative Justice Act. We can bring applications to compel. I spent 3 to 4 years following the recommendations in the Duma decision. I now compel the Road Accident Fund to make an election. I bring an application to compel the HPCSA to convene. I often bring an application to compel the HPCSA to give me their reasons. I'm then often faced with incorrect findings. And when I say incorrect, I mean patently incorrect findings. I'm then constrained to bring an application for review, which I do. Our courts readily overturn the incorrect findings that are being handed down, but what they are not prepared to do is make a finding on seriousness themselves. The result is that we are then directed back to the HPCSA, who then convenes another tribunal and makes a second incorrect finding. I'm then left with no right of recourse at all, and my client then has no entitlement to general damages at all. And when I say patently incorrect, I think it's important to put it in perspective. These clients that I'm talking about often are incapable of finding work. Their marriages fall apart, their relationships fall apart. They stop going to church, they stop socializing, and month after month after month, I watch as they're incapable of putting money or food on the table. They just can't generate an income, and it's not for lack of trying. And it's these very same clients whose injuries are being declared non-serious by the HPCSA. This is not what the legislature intended when Regulation 3 was drafted. The intention was to get rid of the strains and the sprains, the strains, the bruises, the really minor injuries. And general damages was being paid on those injuries, and fair enough, I agree they had to go. But it was never the intention of the legislature to deny the type of individuals I'm talking about now access to non-pecuniary loss. So the HPCSA process is fraught with problems, and what compounds those problems is a complete lack of access to the courts. And this is something that we're currently now challenging. So, like I said, the parallels that can be drawn from that process and that which will happen under RABs, if it is implemented in some or other form, are striking. You have a situation in RABs where the administrator has genie-like powers. They can say, if you get benefits, they can stop those benefits. They decide who you're assessed by. They can decide who you go back to for employment training. And when they do make a finding, or they tell you that your injuries are not serious enough to qualify under those benefits, you fight the battle unarmed, because the accident victim under the new legislation has no entitlement to legal representation at all. So the strikings really are parallel. I mean, I should say there are striking parallels to be drawn. So that's, I think, the RAF4 process. I'd also like to talk a bit about access to the courts, because we talk about access to the courts being denied under the Regulation 3 process, which is the case. But access to the courts over the last 10 years has become more and more problematic. Judge Claessens would be better equipped to tell me when, but if I remember correctly, in 2014, the Chief Justice gazetted a document which placed an obligation on our courts to implement appropriate case management protocols. Now, these case management protocols, or the right of the Chief Justice to do this, is entrenched also in our Constitution. So there wasn't really a problem with gazetting that in itself. If one looks, however, at the manner in which these case management protocols have been implemented, again, it's resulting in a denial of access to the courts. We are jumping through hoops to get to the steps of court. A court is required to, I'm okay for time. A court is required to apply the law fairly and without fear, favor, or prejudice. This is well entrenched. But we find a system of case management where we are coming before the courts in certification conferences where we are being denied certifications of readiness for reasons which are not appropriate. We find ourselves being turned away from the courts. We find ourselves complying, and I don't know, Romini would have a better idea in the Cape, but in Gauteng, we find ourselves complying with protocols and having our matters going into a court system where we're waiting 7-8 months for a certification of readiness. We're then waiting 2 to 2.5 years for a trial date, sometimes a bit less, but we are often getting to the steps of court and there's no availability of judges. What this means, in my context for my talk today, for the accident victim, is this client who hasn't been able to put food on the table, he hasn't been able to work, we see their lives fall apart. And you now sit in a situation where he's now told, yes, this was your day in court, but you know what? There are no judges. Come back again in 3 years. This is not what the legislature intended.
Unfortunately, you're right.
I wish I wasn't.
Unfortunately, you are.
Yeah. But Herman, I think that about sums up where I was. I would like to talk, if I've got another few minutes, just on solutions, because now that I've moaned and griped and told everyone how bad the court system is, I just want to talk about a couple of solutions for the RAF and for the courts. Firstly, when it comes to the RAF, and this is not only the RAF, it's across the board, there are attorneys, it comes to medico-legal professionals, there has to be training. And my suggestion is compulsory and ongoing training. Not just training clinics. There must be consequence for failure to attend these training clinics. and the training needs to be ongoing. There needs to be sanction for non-performance. If an attorney or the Road Accident Fund doesn't fulfill their legislative mandate, there has to be consequence. At the moment, there's no consequence. I shouldn't say no. I know that the Road Accident Fund has its own mechanisms in place, but we see the same attorneys come to court time and time again, unprepared for trial. We see the same claims handlers not giving appropriate instructions. And don't get me wrong, there are plenty of attorneys who are at fault here as well. I'm not laying the blame at defendant attorneys. Plenty of attorneys, we have our own problems as well. But there has to be sanction. There has to be some sort of consequence for non-performance. Defendant attorneys often struggle with the Road Accident Fund. They can't get instructions out of the Road Accident Fund. There are protocols in place. Executive summaries have to be prepared. Very often those summaries are prepared, and they're still not getting instructions from the Road Accident Fund. So there are problems across the board. So that sanction for non-performance has to be implemented. I also suggest better record taking. You've got record of finalised matters, you've got record of how much money is paid out by the fund, how many claims aren't settled, are settled. How about taking records of matters that are postponed by specific firms of attorneys, or matters that aren't finalised by specific employees of the RAF, because that's where the problem is sitting. One needs to root out the individuals that are not performing appropriately. And my last point on solutions was to address the case management protocols. We have a set of court rules to follow. I know our courts are inundated, but the solution to the problem is not delaying the trial process, and it's not delaying access to the courts. All that's happened is we've now got a bottleneck. So those management protocols also need to be addressed urgently. Thank you.
Thank you very much, Lee.